regular checks or being notified by a third party, customs officers may determine that the actual bunker quantity in the tanks of a vessel may be different than the declared quantity to the customs office. In such case, if a deficiency or surplus is determined by the customs officers, it is likely that the crew members face criminal charges on the allegation of bunker smuggling. Such deficiencies very often arise due to innocent clerical mistakes or simple miscalculations of the bunker quantity. However, although in principle the crime of smuggling could only be committed deliberately, in practice local authorities adopt very strict approach by triggering the judicial process in any event. In other words, I would like to note that in case of undeclared bunkers, the matter will be related to criminal liability instead of customs regulations. Despite the previously explained surplus or shortage of declared cargo to the customs authorities, in this scenario it will be related to the criminal liability of the crew members mostly. The reason for such difference is that the bunker existing on board the vessel as fuel is exempted from taxation under our local law. Therefore, in compliance with regulations in force, customs fine is unlikely to be an issue in the matters of this kind. But such issue is even worse, rather likely to fall under criminal responsibility due to alleged bunker smuggling. If the customs officers determine any undeclared bunkers on board the vessel, then the excessive bunker amount will be debunkered from the vessel. If such debunkering is not possible due to the possible setting problems of the subject bunker, to cover the public loss, a security in the value of the excessive bunker amount may be requested by the customs authorities. Such security is usually requested to be deposited in cash. And without submitting the same, the vessel may not be allowed for departure from the related Turkish port. Mostly such criminal proceedings are expected to be commenced against the master and the chief engineer due to their ranking. And as per Turkish criminal procedure code, there are two phases of criminal proceedings. One of which is the investigation phase and the second is the prosecution phase. Once the public prosecutor is notified regarding the occurrence of the subject crime, he will proceed with undertaking an investigation in order to determine whether there is a necessity for commencing a prosecution or not. For this aim, the public prosecutor will obtain statements of the crew members and will proceed with collecting evidence. At this point, I would like to note that it is very important that the initial statements of the crew members are provided properly, because they will have a significant role how the matter will develop later on. Based on the collected evidence, the public prosecutor may prepare his indictment if he is of the opinion that such crime has taken place. The public prosecutor concludes the investigation as soon as the level of collected evidence is sufficient for preparing his indictment. Only the public prosecutor has the discretion to decide whether the investigation phase is completed or not. Once the indictment is prepared, the same is filed to the criminal court, to the local criminal court, and the court must approve such indictments submitted by the public prosecutor so that the prosecution phase starts. If the indictment is accepted by the court, then a criminal action will be commenced against the related crew members, and which will be the master and chief engineer in most cases. similar cases, the indictment is prepared in order to publish the suspects due to alleged breach of the rules under the Code for Fighting Against Smuggling and of the Turkish Criminal Code, which regulates the confiscation. If it becomes the case, the defendants are rather likely to be tried pursuant to Article 3 of the anti-smuggling law. As per the related articles, it is stipulated that a person who smuggles goods into Turkey without carrying out the necessary customs formalities shall be punished with imprisonment of 1 year to 5 years, along with punitive fine up to 10,000 days. As per the same article, if the contraband consists of bunker, the punishment shall be twice and shall not be less than 3 years in any event. During the criminal proceedings, the accused crew members shall attend at least a hearing before the Turkish Criminal Court and render their verbal defense during the hearing. In case such defense is not provided to the court by the accused crew member, then the crew members will be brought to the nearest criminal court to take their statement if they enter into Turkey and as per the order of the criminal court. During the course of criminal proceedings, the vessel may face the risk of confiscation, where it is believed that the vessel was being used as a tool which is produced or designed for the purpose of smuggling. In order to have the vessel released, in most of the cases, a bank guarantee in the amount of the value of the vessel has to be submitted to the criminal court file. However, the type and the amount of the security is always subject to the discretion of the criminal court, and it may depend on the discretion of the criminal court for each and every single case. Should the accused not sentenced to a judgment or a criminal case is not commenced against the owner, then the submitted bank guarantee will be returned to the owners. Every single case has its unique characteristics, and we remain at your disposal to offer our clients the tailor-made services as practicing lawyers and claim handlers, together with our outside customs experts, and it is of importance how the procedures with customs is handled, starting as of the day one, because the very early stages has a significant role on how the matter will develop. For particular cases as well as for detailed information, our contact details can be found on our website, and our LinkedIn posts may be followed for recent updates. Thank you for watching.